Hello, welcome back to Legal Brain. Today, I'll be discussing about the topic quasi-contract. And this is one of the important topic and, all the students will be having doubt in this particular area. So I will be discussing about what do you mean by quasi-contract, what are the sections falling under quasi-contract and so on with examples. So first of all, I'll be discussing about what do you mean by a quasi-contract. And first of all, I would like to tell you that the name or the word quasi is not there in Indian Contract Act. I mean, the term which is not used in Indian Contract Act. But there is a concept called quasi-contract under this Indian Contract Act 1872. So I will be discussing about that particular concept today. So look into the screen and try to understand. First of all, regarding quasi-contract, what do you mean by a quasi-contract? A quasi means almost or apparently, but not really. And a contract means an agreement which is enforceable by law, as you all know. So the meaning of quasi-contract is, in reality, there is no contract between the parties. There is no contract between the party. There won't be any offer. There won't be any acceptance, or there won't be any, you won't see any elements or essentials of a valid contract. It is just that it is an implied contract. There is no real express contract in case of quasi contract. And look into the screen. A quasi contract is not a contract at all, because the essential elements, as I've told you, for the formation of a contract are absent in this particular case. It is, quasi contract is treated as just an obligation by a party to the other party, and which is imposed by law upon a person for the benefit of the other person, even in the absence of a contract. And it is based on the principle of equity, which means that nobody should be, enriched, or nobody should be, enriched, or nobody should get a benefit out of the loss of the other person. Like imagine two persons, A and B. A is spending his own money and doing something, and B is getting a benefit because of that particular act, which is or thing which is done by A. Then, according to this particular concept of quasi contract, B is supposed to share a little money, to A, because B is using the particular, enjoying the benefit, or using the thing, or enjoying the benefit out of the act of A. So this is not a real contract. There won't be any essentials of a valid contract. There is no offer. There won't be any acceptance. But there is an implied contract imposed by law. So the salient features of quasi-contract, first of all, a quasi-contract is not a real contract. There won't be any contract. There won't be any agreement between the parties, but which is just an implied, contract. Second one is, it is not based upon offer or acceptance. I told you, there is no offer or there is no acceptance between the party. One party is doing a particular thing and B, the other party is enjoying the benefit. So obviously, by law, there is an implied duty or obligation on part of the B, the other party, to pay a certain amount to A for the benefits he enjoyed. Next point is, it does not arise from any formal agreement, but it is imposed by law. As I've already told you, there is no contract between two parties A and B, but B is obliged by law, or B is having a duty, by law to give money to A for the benefit he enjoyed. Next is, it is a right which is available not against the entire world, but against particular persons only. For example, I have done a specific thing and you are also getting a benefit out of it. The meaning is that you have to pay me a certain amount, not everybody. So it was just between me and you. Next is the concept of doctrine of quasi-contract. What do you mean by that? As you all know, the doctrine of quasi-contract is based on the concept of principle of equity, which means that nobody should get rich out of the loss of the other person. It says that unjust enrichment, we use the word unjust enrichment and quantum merit. Unjust enrichment means, declares that a person shall not allow to enrich himself, that means to get rich or to enjoy a benefit at the expense of unknown parties. Nobody is allowed to enjoy a benefit or to get something because of the, out of the, expense of other person. Like, for example, we both are neighbors and I'm constructing a bridge, a bridge, and you are also using that particular bridge to go to your house. So I did something, construction of a bridge, and I spent my own money for that, and I didn't take any money from you, and you are enjoying the benefit of that. That means you're using the bridge. In this situation, you are not allowed to have an unjust enrichment. The meaning is that you are not allowed to get the benefit of that without paying any money. So, according to law, law is imposing a duty on you to to pay money for me, a certain amount of money for me for the benefit you are enjoying. And next is quantum merit. Quantum merit meaning is the actual value of services performed. For example, I have constructed the bridge. So how much it cost? What is the actual value of that? And it determines the amount to be paid for the services when no contract exists between both of them. Like so for example, I have spent 1 lakh rupees to construct the bridge. Then obviously you have to pay me 50,000 rupees a share from your side if you are enjoying the benefit of that, because this is based on the principle of equity and unjust enrichment, and you're not supposed to enrich yourself because of the my on based on expenses that I have faced. And when there is a doubt as to the amount due for the work performed but done under circumstances when payment would be accepted. So the meaning is that nobody is supposed to get enriched out of the expense which is met by other party. So because of that, you have to pay the amount or the share of the particular thing the other party has spent or constructed and so on. And now I'm going to discuss about the different kinds of the quasi contracts which is mentioned under Indian Contract Act. Mainly it's from section 68 to 72, so I'll be discussing one by one about all the sections. First is section 68, which speaks about supply of necessaries to a capable person, claim for necessary supply. That's what we call generally. And it just mentioned under section 68, and the meaning of this particular thing is that if a person, if a person incapable of entering into a contract or anyone whom he is legally bound to support is supplied by another person with necessaries. For example, one person, myself, I am giving, a lunatic or an incapable person, a lunatic or, a minor person or anybody like that. If I am providing certain necessaries, I'm supplying necessaries to that particular person to support himself, then I am supposed to, get the money back from him. That means I can reimburse the money. Reimburse money means to get back the money, that I have spent for him or the particular incapable person. Let it be a minor, let it be a lunatic, like that. If I am spending money and if I am supplying necessaries, which is essential for your life to you, then I am supposed to get the money back from you. Example, A supplies B, a lunatic. B was a lunatic person and A supplies B with necessary suitable for his condition in life. And now A is entitled to be reimbursed from B's property. A can get back the money from B, the lunatic person's property. So this is the meaning of section 68, supply of necessaries to an incapable person. If one particular person, let it be myself, if I am supplying necessaries, which is necessary for the condition of life of a lunatic or a minor, I am supposed to get back the money, to reimburse the money from that minor's or lunatic person's property. Actually, section 60 is kind of a problem question you can expect in problem question in the subject of law of contracts, and you may get the facts of the case like A have supplied necessaries to B, a lunatic, or A have supplied necessaries to B, who is a minor, and now will he be able to get back the money? Obviously he will be able to get back the money because this is a quasi contract. And even though there is no contract between A and B, law imposes a duty on B to repay the money to A. So this is a quasi contract. So if you get a question, a problem question like this, don't get confused. It is yes, he can get back the money because it is a quasi contract under section 68. Next is payment by interested person, that is section 69. And the meaning is that if a person who is interested in payment of money, which another is bound by law to pay and who therefore pays it is entitled to reimburse by the other. For example, I am supposed to pay, 10 lakh rupees to B. Okay, I'm supposed to pay 10 lakh rupees to B. And for the time being, I am not having money, and other person C paid the money on behalf of me to B. If that is the situation now, C is having a right to get reimbursed from me. That means I am now, liable to pay the money to C because he have already paid the particular amount, 10 lakh rupees to B, whom I was obliged to pay. Look into the example. One person A holds a land in a Bengal on the lease. Okay, one particular person, let it be me. I am, holding a property, a land in Bengal on lease. It's in lease. I am having the property, and B is the owner of the particular land. Now, the land revenue, we have to pay the tax, and the land revenue payable by B to the government is in arrears. That means B, the person who is the owner, who is supposed to pay the the tax, the land revenue to the government, he haven't paid the particular tax, and it's in arrears. That means it's like many multiple times he haven't paid the particular money, the tax, and now it's in due arrears. And now A is paying the particular arrears, on behalf of B to the government. If this is the situation now, after making the payment to prevent the sale of, in the particular example, the government advertised the land for sale to recover the dues. Government have taken a step and, advertised for the sale of the land. And to prevent the sale of the land, A pays the arrears to the land revenue. Like A paid the arrears on behalf of B. In this case, now B is bound to reimburse the amount to A because I have, paid the money for B. I have, paid all the dues, all the arrears of land revenue. Now B is supposed to pay me money. I'm supposed to get reimbursed to get the money back from B because I have made a payment. I am the person, the payment by interested person under section 69. This can also be a problem question. So you have to thoroughly study section 68 and 69. And the next section is section 70. Section 70 speaks about payment for non-gratuitous act. And the meaning is that when a person lawfully does anything for the other person or delivers anything to him, not intending to do so graciously, and such other person enjoys the benefit out of it and later is bound to make the compensation to the former, the other party, in respect of or to restore the things so done or delivered. I'll give you a simple example for this particular concept. One person A, who is a tradesman, leaves his goods at B's house by mistake. A has kept his goods in B's house by mistake, and now B treated this particular goods as his own goods and using the particular goods. Now, B is bound to pay for the goods to A because B was using the particular goods, and now B is supposed to pay the compensation or the money back to A. That means when a person is lawfully does anything for other person, legally is doing something or is delivering anything to him, not intending to do so. Okay, it was like by mistake. If that is the situation, if he is enjoying the benefit out of it, the other party is supposed to make the payment or to compensate the first party or the original party. That is mentioned under section 70. The next concept is section 71, which speaks about liability of finder of goods. So this is an interesting section, and again, this is a problem question, and it says that a person who finds the goods belong to the other person and takes them into his custody is subject to the same responsibility as that of a bailee. Bailer and bailee, bailer is a person who, delivers the goods to the other person, bailee, and he's, taking care of it. And the thing is that in such situation, if I lost a particular goods, if I lost my goods, and if you got the goods, you should take care of the goods, and you should actually, find the owner who is the real owner. For example, I lost my purse, and you have the custody of the particular purse, and you are the person, who find out, who found the goods. So you are called as finder of goods. Now it's your responsibility to keep the particular person in your safe custody, to take care of it, and to get it back to me once when you found that I am the original owner. Next is duties of a finder of goods. What are the duties that a finder of goods have? First one is he must try to find out the real owner. He's supposed to find out the real owner, who is the owner in the curse, in this particular curse. Like, if I lost my purse, I am the real owner, and you found out that. Second one is, if the real owner is traced, he must restore the goods to him on demand. Like, you can actually get it back to me. Even you can ask for a little amount of money for, keeping it safe from me. And further to the goods are in the possession of the finder, he must take as much care as the goods as a man of ordinary prudence. That means if you are having a particular product, a lost good, you should take care of it as a man of ordinary prudence, as a man of ordinary thinking. You have to take care of it. And under similar circumstances, a take of his own goods of the same bulk, quality, or value. That's mentioned under section 151, duties of a finder of lost goods. So I have given you an example, like, if I lost my purse, think about I lost a living thing, like a dog, okay? And if you found out my dog, you are supposed to keep the dog safely in your custody. You are supposed to feed the dog, to take care of the dog, and so on. And once when you trace the original real owner, that's me, I can actually give you money. You can actually claim money from me for the money you have spent for my dog. So this is the Quasi contract. The last point is section 72, which speaks about payment of delivery by mistake or under coercion. I'll give you a simple example. For example, I'm supposed to pay money to B, but mistakenly I thought B is C. I paid the money to C. Now I am actually, I paid money to in this situation, if I pay the money to C, thinking that it's B, now C is supposed to make the particular payment to B. Example, look into the screen. A and B jointly, and this is another example, like A and B jointly owe rupees 5,000 to C, and A alone pays the amount to C, and now B not knowing the particular thing, again pays 5,000 to C. In this situation, C is bound to repay 5,000 rupees to B. So yeah, this is the situation, if there are three parties, one, A paid money to B thinking that he is C, then, if I am making a payment to B thinking that it is C, then B is supposed to make the payment back to C. So these are the different, quasi contracts, mentioned under section from section 68 to 72 under Indian Contract Act 1872. And you won't be able to find the word quasi under Indian Contract Act, It's all about necessary supply. And in conclusion, a quasi contract exists in the absence of a written contract. I told you, which is not a real contract. There is no offer. There is no acceptance. It is just an obligation which is imposed by law and may be court ordered to avoid one party gaining at the expenses of another party's action. That means, no person should get rich, unjustly enriched, no person should be able to, get rich, or court prevent the person from, getting unjust enrichment. So this is the concept of quasi contract. I hope it's clear for you from section 68 to 72. If you do have any queries or doubts, do comment below. Thank you for listening to me, and do subscribe Legal Brain. Thank you.